We good to start?
Yeah.
Getting the thumbs up. Welcome to our celebration of Constitution Day. It's great to see all of you. This event is brought to you by the Vermont Judiciary, the Vermont Bar Association, and of course, Vermont Law and Graduate School. My name is Andrew Minitsky. I'm the president-elect of the Vermont Bar Association. I take office in 2 weeks, and I'm an attorney in private practice in Burlington. Today, I'm substituting for Bob Fletcher. I know that Bob regrets not being able to be here today, and not only because allowing me to speak to a big group like this is often dangerous. Nobody is quite sure what I'm going to say, but also because I know that he's sad to miss out on this incredible panel of judges that we have here for you today. The Constitution was signed in Philadelphia on September 17, 1787, and this day, Constitution Day, was established under federal law. The site is 36 USC 106, for those of you who like citations. I know we all do. And it was established to celebrate and recognize the Constitution. This year's theme is Toward a More Perfect Union, the Constitution in Times of Change. Of course, this aspirational phrase, a more perfect union, comes from the Constitution's preamble. Now, I'm told that each of the 5 panelists will have a maximum of 10 minutes to present, and that there is a timekeeper in the front row who will handle logistics. Hi, timekeeper. I will not be handling those logistics. I learned a long time ago that when a judge is speaking, you don't interrupt. So I'm not going to be interrupting any of the judges today. Chief Justice Reiber will start by discussing state court constitutional decisions affecting the voting rights of displaced soldiers after the Civil War. The remaining 4 panelists will discuss cases in which the U.S. Supreme Court has overruled established constitutional precedent. And we've seen that that happens from time to time. Those presentations themselves will be introduced by Judge Teachout, who will provide an overview. Again, we're going to start with the Chief, and by way of introduction, Chief Justice Paul Reiber graduated from Suffolk Law School in 1974. He served in private practice in Rutland and was appointed to the Vermont Supreme Court by Governor Jim Douglas in October 2003. The next year, he was sworn in as Chief Justice. Chief.
Thank you, Andrew. Thank you, and good afternoon, everybody. Welcome. It's nice to see so many smiling faces. Appreciate you coming. 2 of us here are justices on the Vermont Supreme Court. My friend Bill Cohen, Justice Cohen, and myself, obviously. There will be 2 judges. Judge Tomasi is here, Judge Tim Tomasi, and Dan Richardson, who is 5 minutes away and on the interstate in an unbelievable, I can attest to that. Professor Teachout's spouse is filling in for him with by Mary Teachout, who's one of the trial judges on the Vermont trial bench, in case you folks did not know that. And Mary is going to take over. I'm sort of an outlier. When Professor Teachout pitched the ABA theme, Toward a More Perfect Union, and did an incredible amount of work to tee us all up on U.S. Supreme Court decisions that had effectively been reversed another direction, and he was kind enough to go along with me, which I am grateful for. So I hope you'll tell him that, Mary. So let me begin. As Andrew said, the piece I want to talk about has to do with voting rights of Civil War soldiers who were fighting in the Civil War on both sides of the battle. So I'm going to read you my presentation. Here it goes. This presentation concerns suffrage rights. in particular, a group of cases from the Civil War era, the Civil War soldier voting cases. These are state Supreme Court decisions from several states construing voting laws and efforts to enact such laws under the state's respective constitution. Prominently, I will reference an 1864 Vermont Supreme Court opinion that, in reaching its conclusion, evaluates efforts in other states to give displaced and remote Civil War soldiers a vote in state and federal elections taking place in their home jurisdictions. This viewpoint is therefore somewhat different than the others who are on this panel, but similar in an important respect. Working towards a more perfect union, which is the ABA's theme this year, from the perspective of the state courts, is often thought to entail a vertical relationship, that is, state courts following federal courts. But working towards a more perfect union from the perspective of state courts has also entailed a horizontal relationship, states borrowing from other states. The Civil War soldier voting cases demonstrate the importance of this horizontal perspective. During the Civil War, many states attempted to pass laws allowing soldiers stationed outside their respective voting districts to cast ballots for federal and state elections. In some instances, these laws ran afoul of state constitutional provisions mandating the place of voting in elections. The Vermont Supreme Court issued one of the leading opinions in this area, an 1864 advisory opinion known as the Opinion of the Judges of the Supreme Court of Vermont on the constitutionality of an act providing for soldiers voting. So let me interrupt my presentation here to tell you that we do not have advisory opinion jurisdiction under our Constitution. This was a point of concern that was raised in this case and never fully vetted, and the Vermont Supreme Court proceeded regardless to issue an advisory opinion. Many states have jurisdiction under their state constitutions to issue advisory opinions. We do not. This is an outlier in that respect. In its opinion, relevant decisions of other states were carefully examined by the Vermont court, and then ultimately its opinion was actually followed by other states. The court held that the Vermont Soldier Voting Act was unconstitutional as to the submission of ballots in state elections and constitutional, however, as to the submission of ballots in federal elections. By this decision and others, through the horizontal perspective, the states managed to move towards a more perfect union under incredibly difficult circumstances. The opinion demonstrates the importance of this perspective. Civil War soldier voting was described by Josiah Benton, a Boston lawyer and Civil War veteran who was born in Vermont, in his 1915 book entitled Voting in the Field, A Forgotten Chapter of the Civil War, as an important phase of the Civil War which is passed without consideration and with little notice by historians of that period. Notwithstanding this inattention, voting in the field was provided for or attempted to be provided for in 25 states throughout the Union and Confederacy from 1861 to 1864, including Vermont, Connecticut, Pennsylvania, New Hampshire, and Iowa. 19 of these states enacted soldier voting laws. In a 2002 Law Review article, Hayward Smith, a lawyer from New York, wrote that the main issue with these laws was that the state constitutions at the time of the Civil War contained provisions which could be interpreted to require voters only to be able to cast votes within their state or within their town's borders. According to another scholar, the Civil War period brought with it the first serious attempts to enfranchise military voters. Indeed, only Pennsylvania had a soldier voting law at the beginning of the Civil War in 1861. The enactment or attempted enactment of these laws reflected the popular sentiment that the widespread disenfranchisement of soldiers was unjust, especially because it was only by virtue of their service-related absenteeism that they were unable to cast their ballots in the manner prescribed by law. So deeply was this felt, according to Benton's 1915 book, that Connecticut, Kansas, New York, Maine, Maryland, Michigan, Pennsylvania, and Rhode Island amended their constitutions so as to authorize voting in the field for state officers as well as for presidential electors and representatives in Congress. One historian, writing in 2000, suggested that the enactment or attempted enactment of soldier voting laws also reflected the popular belief that recruiting and retaining an army would be difficult if soldiers or potential soldiers were prohibited from voting. Lastly, some scholars believe that the soldier voting program reflected partisan political motives. While soldier enfranchisement has proven to be an emotionally resonant issue throughout American history, although not continuously, the scale of the movement to permit soldiers to vote in the 1860s was unprecedented. Legislatures seeking to guard the soldiers' elective franchise found considerable and apparently unexpected difficulty in doing so. It was feared by some that if the soldiers were given a ballot, they would vote as their officers dictated, and thereby the civil control of the state might be subordinated to the military power. The issue of field voting included the issue of state elections on the one hand and federal elections on the other, although this distinction was often not made by other states in their decisions. But Vermont's Soldier Voting Act of 1863 set up an elaborate scheme for voting in the field for both state and federal officers. And in their 1864 opinion, the court here in Vermont held that the legislature may not allow for voting out of state, or indeed voting outside the local gatherings of eligible voters in freemen's meetings. However, the court held that the legislature could allow for field voting in federal elections. The court distinguished field voting in state elections. Are you telling me I'm out of time?
He is.
Move your mouth. Can I? Yes. Oh. So let me move to the conclusion, Mr. Timekeeper.
He does this in court all the time. He says you have 1 minute left, and then when you're done, he hits the button. So don't feel bad.
Yeah, you don't have a red button. I'm glad. So the point here is that the Vermont Supreme Court made its decision that because of the language in our Vermont Constitution that required at the time that voters be present, physically present within the boundaries of the town in which they cast their votes, that constitutional provision of ours meant that soldiers who were obviously at the front lines of the Civil War could not be provided ballots to cast their vote, in this case for Abraham Lincoln, who was running for re-election at that time, for the ballots to be shipped back to Vermont to be counted. So that was the decision of the Vermont Supreme Court. However, because our Constitution made no reference to federal officers, to the election of federal officers, to the election of the president, or the election of members of Congress, because of that, it was entirely acceptable for the legislature to permit soldiers to vote in their locations where they were engaged in battle, and for those ballots to be shipped back. And in fact, in the election of 1864, when Abraham Lincoln was reelected, that is the case that occurred with regard to Vermont's ballots, and with many of the other states in the Union, both in the North and in the South. Some states' constitutions were actually amended to permit soldiers to vote both for state officers as well as for federal officers. So, in conclusion, there is, I think, a very important perspective to be placed upon the question of stare decisis, if you will, of reference to decisions that are not necessarily authoritative in that sense of stare decisis, but reference to decisions of other states that help to inform the rationale and the decision that our state came to in this particular instance. And that decision, in fact, was followed by many other states because of the thoroughness of the opinion and the logic that was applied by the Vermont Supreme Court. So that's my presentation. I appreciate you listening. I'm sorry, Mr. Timekeeper. I'm glad you didn't have a red button.
That's all right. I can do it from over here. Wherever you want, wherever you'd like me. Judge Mary Miles Teachout graduated from the University of Washington Law School in 1975. She was in private practice until being appointed a Superior Court judge in 1992 and was a judge until her retirement earlier this year on February 1, which was disappointing. She served in Washington County, Caledonia County, and Windsor County Superior Court. Judge Teachout.
Good afternoon. I'm here today as the understudy for Professor Peter Teachout. I think some of you know him. He is the constitutional scholar and teaches constitutional law. I'm just a trial judge, but he had been waiting months and months for surgery on his foot, and they scheduled it for this afternoon. So I'll do my best as his understudy. The theme is toward a more perfect union, and so we are going to shift now from state constitutional law to the United States constitutional law and look at it from the perspective of what happens when the United States Supreme Court overrules a precedent that it had previously established. When that happens, and how often does it happen, does that have the effect of moving toward a more perfect union, or does it have the effect of disruption? And that might be different depending on what the particular overrule decision is. But that's what we're going to focus on, and as we discuss different cases, it's really up to you to consider whether or not you think the effect of an overruling has been toward a more perfect union or not. And the springboard for this discussion is the recent situation of the overruling of Roe versus Wade. Roe versus Wade was the decision of 1972. It was made just as I was starting law school. And the decision is widely considered to be an abortion decision. And it was grounded, however, in the Due Process Clause of the 14th Amendment of the Constitution. Here's the Constitution. It's pretty thin. And Terry has very nicely put out a display of samples of you to take this. It's kind of a handy thing to have. And the Due Process Clause is just one tiny little bit. But the ruling was that that individual persons have a constitutional right to make personal choices about their personal family life, including things like contraception, intimate sexual relationships, and family planning. And that no state would be permitted to enact legislation that interfered with that, at least up to the point of viability. Viability is when a fetus has the potential for life on its own. And so, of course, it was controversial at the time and has been over years, but it had been in place for 50 years. And states did enact various things for different periods of time and to protect different forms of life, but that was the basic constitutional principle. As you probably know, this year, 2022, 50 years later, the United States Supreme Court overruled that decision. And the decision was that there is no such constitutional right. It was an absolutely black and white overruling. And the court and other courts often doesn't absolutely overrule a prior decision. They very often distinguish one case from another case. For example, there was a case that the United States Supreme Court decided in which they said that it was unconstitutional for a state to not allow a person to apply for welfare until they'd lived in a state for 6 months. Well, a few years later, they made another decision. Somebody appealed a law that said you couldn't get a divorce until you'd lived in a state for 6 months. Well, the United States Supreme Court said, oh, well, that's different. We're not overruling our prior decision. Our prior decision was that it was unconstitutional to interfere with the right to travel of the poor. This is not about that. This is about anything else. So very often they distinguish a prior ruling from a new ruling. But in this case, in the Dobbs case, Dobbs versus Jackson Health, they absolutely said they were overruling the Roe versus Wade decision because it was wrongly decided. And it was a 6-3 decision. There's a very vigorous dissent. Actually, 5 members of the court signed on to the principle that it had originally been wrongly decided. And the Chief Justice said it wasn't really necessary to overrule Roe versus Wade, but he still agreed with the result. And one of the primary bases of the reasoning was to go back to 1868 when the 14th Amendment was enacted and became law. And the idea was that there was no such constitutional right in 1868, and therefore it's really not a fundamental constitutional right. The important thing to remember about overruling decisions is what is the law and the important principle about when the court would overrule a prior decision of its own. And it is the principle of stare decisis, but there are 2 fundamental reasons that the court usually tries not to overrule its prior decisions. One of them is that this is the Constitution, and it's supposed to represent principles of stability over time. People organize their lives based on, and governments, state governments and institutions organize their lives based on what they understand the law to be. And for 50 years, in the case of Roe versus Wade, people understood what the law was. And so if a decision is overturned, it has an impact of perhaps creating instability. It may also have an impact of creating greater fairness, but that's something to be considered too. But the main idea of the principle is to create long-term stability of legal principles. The second reason is that people would have faith in the fact that the justices of the Supreme Court are not acting on the basis of personal political ideologies. that this is, you've probably heard about the fact that appellate judges very often, and actually trial judges too, they don't agree with something. They think, oh, if only that had been decided the other way, that would have been better. But it's been decided this way. I have to go with it, even though I don't agree with it. And of course, we expect legislators to act according to their political ideologies. And when there's an election and the party shifts from one to another, we expect that to change. But the idea is with the United States Supreme Court, we don't want the winds to shift constantly based on changing political ideologies. Constitutional principles should be long-term, abiding things. Well, we're talking now about decisions which precedent has been overridden, but it actually hasn't happened very often. In fact, statistically, a clear override has only happened 145 times out of 25,500 decisions made by the United States Supreme Court over the years. So that's around 0.5%. So it's really actually quite rare. But what happens when it does happen? There are other examples that have happened over time. For example, in 1937, there had been 40 years previous to that where states had tried, some state legislatures had tried to enact laws respecting worker rights, minimum wages, and things like that. And the United States had always struck that down, saying there's a right to contract. It was part of the laissez-faire economic principles. There's a constitutional right to contract. But then after the New Deal and the United States Supreme Court changed that and actually said, no, there isn't any constitutional right to contract. That's not in the Constitution anywhere. That's one example. There are a couple of other examples that I was going to give, but I'm getting the message from the timekeeper. And so at this point, let me just point out that with respect to the Dobbs decision, one of the interesting things about it is that it is a rollback of the protection of individual constitutional rights. We've had many in which constitutional rights have been expanded, but this is one in which the override decision actually rolls individual rights back a little bit. We are now going to hear 3 different presentations from Justice Cohen first, and then the judges, dealing with other different critically important decisions in which the United States Supreme Court has overridden precedent. Justice Cohen will talk about an important decision regarding racial segregation and the Equal Protection Clause. Judge Tomasi will talk about free speech, money, and politics, and how that relates to the constitutional provision of free speech. And Judge Richardson will talk about the government funding of religious activities relating to the Establishment Clause. So it is, and as you hear each of these, keep in mind the question, the overriding question, when the United States Supreme Court overturns an established precedent, is it in that particular case, or is it not a movement toward a more perfect union? Now, Justice Cohen.
And just to, thank you. Vermont Supreme Court Justice Bill Cohen graduated from Vermont Law School. He began his career as deputy state's attorney and then worked in private practice in Rutland. In 1999, he was appointed as a state superior court judge, and on December 5th, 2019, he was appointed to the Vermont Supreme Court by Governor Phil Scott. Justice Cohen.
Good evening, and for anybody who's ever not sat through a Vermont Supreme Court argument, there's a podium there, and on the podium, there's a red light. And when you get 1 minute left, the red light goes on. When you're done, and the chief always says, when you have 1 minute left, counsel, you have 1 minute left. So I'm expecting him to do that today when I get close to the end. And when I was a lawyer, it never bothered me to speak in public. When I was a trial judge, which I was for 20 years, it never bothered me to speak in public. But when I was appointed to the Vermont Supreme Court by Governor Scott, it really bothers me to speak in public because I think the people take the words more seriously. Things have consequences. You can't talk about cases that could potentially be pending in front of the Vermont Supreme Court. So my comfort level on how comfortable I am speaking is greatly limited by being cautious on things I say. But this is about the 4th time I've spoken to this conference, and I think the great part of being able to speak doing this is what I learn when I start these presentations on whatever subject matter there is. And there's so much minutia that is incredibly interesting that I glossed over or never really quite understood. And when I started the presentation getting ready for this, which is Plessy versus Ferguson and Brown versus Board of Education, which is a pretty easy subject matter, I may say, considering all the information and the consequences of both of those decisions, I started by reading the preamble of the Constitution, which I would encourage each one of you to do. And it starts with, "We the people of the United States." And when you think about the words that were chosen for that, "we the people of the United States," it wasn't "we the states of the United States," "we the legislators of the United States." It was incredibly inclusive. Now, I'm not going to say that it was completely inclusive because women were not included and people of color were not included, but it was designed around a democratic principle that the people of the United States, in order to form a more perfect union, that's the next line. And those words themselves become really important because it recognizes that the union was not going to be perfect, and the union probably never could be perfect, but it was to form a more perfect union. And putting the word "more" in there, in my view, clearly indicates the need to adjust every once in a while, to correct, and to keep moving forward. And as much as we can get discouraged on current decisions or on decisions that have happened in the past, that there's always hope, in my mind, of our democratic principles that come forward to allow us to sort of make these necessary corrections when courts don't get it right. And courts don't always get things correctly. One of the most difficult things for me to start with was when I became on the Supreme Court, I had to reverse a colleague who did exactly what I would have done. I mean, it was exactly the way I would have handled the case, an exact decision, but it needed to be reversed. And that was a hard thing to get used to. And that supports what Judge Teachout was talking about. So I'm just going to start with Plessy versus Ferguson, which is a United States Supreme Court case from, hang on 1 second here. So Plessy versus Ferguson was a decision from the United States Supreme Court in 1892. And I learned a lot of history about how the 13th, 14th, and 15th Amendment came about and what states did in order to get around some of these equal protection arguments. And what began with was Congress passed a bill in 1875 allowing a lot more power for the Equal Protection Clause that the United States Constitution in 1883 overruled. And then as the Jim Crow rules and the Jim Crow regulations and the segregation, and clearly racially motivated segregation, starts coming into play in the South, some individuals in Louisiana picked the person Plessy. And Louisiana had a white-only train rule. So you had white cars and you had black cars, or colored cars, I think was the word. And I don't mean any offense on some of the terminologies that were used in the 1800s and even in Brown versus Board of Education, which uses the word Negro. And I mean, no disrespect to anyone I'm just going to use the language that was included there. So during the era of Reconstruction, black political rights were affirmed by the Constitution, and then the Supreme Court struck down the act in 1875, and then the Jim Crow laws started coming into effect in Florida, Louisiana, Alabama, and the like. So they chose Plessy because he was 7/8 Caucasian and 1/8 African American. And they brought the action in front of the, it went all the way through the courts, never striking down this notion that you could have this concept of separate as long as it was equal. And then the U.S. Supreme Court, in a 7-1 decision, they considered it a fallacy, the argument, to consist of assumptions that enforce separation of two race stamps the colored race with a badge of inferiority. And that's what the majority of the decision wrote. And those words become very important later on. There is a dissent. It was a dissent by John Harlan, who in fact was a slave owner, who in fact was very supportive of segregation, very supportive of racial injustices, until he saw what the Ku Klux Klan was doing to black Americans. And when he saw what the Ku Klux Klan was actually doing with, and the murders in the streets and the like, he switched. And he wrote this amazing dissent that is so powerful and so strong, which I'd never read before I was doing the decision, or getting ready for this. He's the opinion that the statute of Louisiana is inconsistent with the personal liberties of citizens, white and black, in that state, and hostile to both the spirit and the letter of the Constitution of the United States. And he wrote that solo. When you write something by yourself in any appellate decision, it's usually trying to say something, but he's saying something much more than getting something off his chest. He's saying it's just not right. And he was very clear. They called him the great dissenter. He was informed of that. And then that's the way the law was in 1893. The consequences of that are severe. If you think about the history of the United States from 1893 up until Brown, which was in 1953 and 1954, there's a lot of things that occurred. There was the Spanish-American War, where race played an important part of keeping blacks out of, limited in their army roles. There was World War I, where again, there was this whole notion of segregated armies. Blacks weren't allowed to be in the infantry. There was limitations on that. There was Prohibition. There was then the Depression. There was a lot of issues involved with that, all including separate but equal. Then there was World War II. And World War II first began under Franklin Roosevelt and actually Eleanor Roosevelt's thing of trying to get to this notion that there was no inferiority on black pilots, and anyone who's seen the Tuscany Airmen know the story with them and their history, and also black infantry soldiers, warriors who were out there fighting for things that could be questioned on their loyalties, and that was a big part of it as well. They thought that they would, if they had blacks in the army, they would become overly powerful. And there's a lot of research on that this is what motivated the U.S. Army's decisions all the way up until 1948. In 1948, President Truman desegregated the Army. And it's still, by desegregating the Army as the president and the commander-in-chief, it still didn't get the Army, the Navy, the Air Force. It still never did it until he had to do executive functioning. And I've got 1 minute left. So then, Brown versus Board of Education comes. And the interesting thing about Brown, which I did not know, is that the first case in Brown was to affirm Plessy versus Ferguson under what Judge Teachout was talking about, stare decisis. The Chief Justice, Justice Finch, dies. President Eisenhower has an opportunity to appoint a replacement and appoints Earl Warren to be the Chief Justice of the United States Supreme Court in the interim. So the first case was going to be an affirmance. Then Chief Justice Warren comes in, the Warren Court comes into existence. It's a 9-0 case stating very specifically there is no such thing as separate but equal. And there is a clear badge of inferiority, and you're never going to do it unless it's equal across the board and desegregate everything. But again, the fact that it was done in 1953, and then they did a subsequent order in 1954 saying this needs to occur immediately, it's still taking decades for things like this to occur. And, but that's the law. And again, the distinction between the two, read some of the subtleties if you get a chance. I know you guys are busy with your schoolwork and the rest, but if you get some chances to read some of the subtleties about it, it's fascinating information. Thank you. I can, sure, I can stand it.
Next, we have Judge Tim Tomasi, who graduated from Columbia Law School. He served in the office of the Vermont Attorney General from 1994 to 2007, where he was chief of the Civil Division and served as an assistant U.S. attorney for the District of Vermont. He was appointed Superior Court judge by Governor Jim Douglas in November 2010. Judge Tomasi.
Thank you. All right. Thank you, Andrew. Thank you, everybody, for coming, and thanks for the law school for this great program. I've been here before. It's always a great time and very informative for, hopefully for me, for sure, and hopefully for you as well. So you see the topic of my speech. I do have, actually it's a 20-minute presentation, but I'm going to speak really quickly. So we'll have to keep up. So it's been up there for a while, so I guess you can see it. We're going to talk about corporate political speech for a little while, but to start and get a grounding on that, you have to go back to 1976 in Buckley versus Vallejo, which was a real effort by Congress to try to stem the tide of what they viewed as being the corruptive influence of money in politics. They passed the FECA law, the Federal Elections Campaign Act. It placed limits on the amount of money you could donate to a candidate, the amount of money a candidate can spend, and the amount of money somebody can spend independently to support the candidate of their choice. The court first found out that those kinds of activities are really First Amendment activities. All three of those things are First Amendment activities, and in fact, really close to the core of what political speech is all about. And so they said, well, we have to apply standard strict scrutiny analysis, which says the only way you can burden a right under the Constitution, typically, is to have a compelling governmental interest and narrowly tailored to meet that interest. The court found that the direct contributions to a candidate and putting limits on those, there was a direct relationship to quid pro quo, we call it, political corruption. Essentially, I'll give you this money, and you're going to give me all the votes I want on these topics. And that was a basis for there to be a compelling state interest. The court found, however, that as far as the candidate spending and the independent expenditures, they were not linked closely enough to the candidate or this quid pro quo danger. And so they said, you know what, those are not constitutional. We're going to fast forward 14 more years to Austin versus Chamber of Commerce. The court considered limits there on the amount of money a corporation can spend to support a candidate. So this is an independent expenditure again. The company wants to try to support a candidate. Michigan said you can't spend it out of your treasury funds. Again, the court found the same burden. It burdens the company's speech, and so it went through the same analysis. But the court considered ideas of corruption that went beyond just quid pro quo. And what they came up with and concluded that the state did have a compelling interest, and it's a bit of a mouthful, but here in curbing political spending due to the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. So the corruption is really kind of three aspects to it: immense aggregations of wealth, created by the corporate form, which is kind of a state creation and it provides protections to the corporation, and there's no correlation. So people invest in corporations because they're good businesses, not because necessarily, in those days anyways, because you like that their corporate, their ethos for who they supported. And the court found that was really essentially a distortion of the process because they had so much money, and they said that corporations spending that kind of exorbitant amounts of money could work distortions into the political realm that were caused really simply by their economic welfare. And they said that is an unfair aspect of the political process, and it's almost as distorting as a direct contribution to a candidate. And so they said, you know what, you can regulate that. Interestingly enough, written by Justice Marshall, commonly thought on the left wing of the court, but also joined by Chief Justice Rehnquist and Justice White, commonly thought on the right wing. After Austin, the court starts expanding the ideas of what is considered to be a compelling corruptive influence in politics. In Shrink, the court identified corruption as being a broader threat from politicians who are too compliant with the wishes of large donors. And in the McConnell case, that said corruption really involves something more subtle and equally dispiriting forms of corruption, and includes the fear that officials will make choices based not on the merits of their constituencies, but according to the wishes of those who had made large contributions. So in essence, really, the court found credible the government's arguments that the huge amounts of money being spent in politics did create and allowed for there to be a distortion of the proper view of what politicians should be doing and how they should be acting. Enter Vermont. It's not really a corporate speech case, but it is relevant. It's a Vermont case, and selfishly, I was the head of the legal team that defended the law, and it's kind of relevant, so let me talk about it for a minute. In the late 90s, Vermont passed a law, Act 64, which tried to limit candidate spending and had very low contribution limits. We defended it, and the legislature made a number of findings to support the idea that there was a new corruption here, because candidates were spending so much time trying to get their resources pulled together in order to meet all the amounts of money you need to run a campaign, that they were doing it to the distraction of their other duties. That was one analysis for a corruption. And we also said that because the legislature in Vermont had a number of hearings, hundreds of witnesses, they had found that contribution limits alone had done not enough to stem the kind of the corruption of access and undue influence of large donors. So we had a partial victory in the district court. We largely actually won in the Second Circuit, unfortunately lost at the Supreme Court. The Supreme Court determined that Vermont's idea of this new corruption was in fact already considered in essence by Buckley and rejected, and that the record evidence that we had was still not enough to support a different result from Buckley. So essentially, they just reaffirmed Buckley's core conclusion. Contributions have a clear relationship to that kind of quid pro quo corruption, and that's the only kind of corruption that we've identified so far. Fast forward to 2010, 4 years after the Randall versus Vermont case, the court had another opportunity to consider the bipartisan Campaign Restoration Act, Reform Act of 2002. They used to have bipartisan laws. That was when I was younger. The U.S. did not even attempt to support remember that three-headed thing I told you about when Austin said, here's our thing? The Solicitor General didn't even put that forward really as an argument for why they wanted to defend it. I think maybe because if you actually took that to its extreme idea, you could pretty much regulate any kind of corporate speech simply because it was created by a corporate form. So it kind of was too broad. I think that they must have determined that. But they offered other kinds of corruption ideas. The government argued that, part of the reason you want to protect against corporate spending for candidates is because you want to try to protect the dissenting shareholders, those people who just want to invest in Amazon because they're a great country, a great company, not because they support Joe Smith who's running for Congress. But the court again said that would allow that was too broad, because that would allow you to regulate media companies, for example. And media companies play such a huge role in discussion of public ideas and in our democracy that couldn't make any sense. And then they also tried to argue, like Vermont had a few years before, that there's this distorting aspect of money in politics, which allows undue influence, access to preferred donors, and preferred people who spend a lot of money in support of you, even though it may not be a direct contribution. Again, Supreme Court said, that's really not, we thought about that in Buckley and we rejected it back then. And this time, we have in the majority, Justice Kennedy, who dissented in the Austin ruling, and he got to write the majority opinion. And we talked a little bit about access. This opinion made clear, though, that favoritism and influence are not avoidable in politics. Ingratiation and access are not corruption, and the government's reliance on general favoritism or influence is at odds with the First Amendment. So there was a period of time from 90 up through 2010 when Citizens United and FCC was on the books, where we were really arguing a lot. A lot of people were putting forward various ideas about what political corruption could mean and how big money really impacts many parts of our political campaigns and election law. And this kind of really made a much narrower view of what the kind of corruption is, and it kind of goes back to Buckley. And essentially that's true. Despite cases with broader views of corruption, the Citizens United Court returned to those principles. Fear of actual or apparent quid pro quo corruption tied directly to candidate contributions to candidates provides a compelling basis to restrict political speech. But other notions, more expansive notions of influence, access, and the distortion of the political process simply do not. In the absence of that kind of compelling justification, the government cannot restrict speech or speakers, especially in the kind of bedrock area of First Amendment freedoms in the arena of democratic elections. So it really rejected the idea, ultimately, Citizens United did, that the money being spent, no matter how much, and you can spend a lot, spent independently of candidates somehow unfairly distorts electoral politics. Essentially, Citizens United concluded that more speech, more money is just more speech, which is essentially, in their view, a First Amendment good. So ultimately, Citizens United places its faith in the political marketplace of ideas and the electorate to sort through the electioneering speech and the myriad political speakers and to make reasoned decisions at the polls. Thank you.
Next up, we have Judge Daniel Richardson. By the way, no introduction. I'm going to give you an introduction. No. Congratulations. I haven't seen you. Judge Richardson graduated from Vermont Law School. He was appointed to the Superior Court earlier this year by Governor Phil Scott. He most recently served as a city attorney and corporate counsel for the city of Burlington, and he served in private practice in Montpelier for many years. He has also served as the president of the Vermont Bar Association and the Vermont Bar Foundation. My friend,
Thank you.
Judge Richardson.
Thank you so much. Let me just, how do I launch it? Just make sure I'm doing it.
Sure.
Excellent.
That should be good. And then you have, okay, your view is a little bit different. That's weird.
Okay. I may have shrunk the other.
You show me what you need.
Oh, it doesn't matter to me.
I think this, is that yours?
Yeah,
Okay.
that's the one.
Let's just stay with that.
Okay.
I think we have what we need on up there, right, for the audience?
I know. Okay. Huh. It's always,
In the right mode.
yeah. You want to get,
Let me just take a seat here.
move my watch.
Excuse me.
Why he does that, I'm going to improvise a little bit. Justice Cohen was saying earlier about the red light, and it reminded me of a very famous story about a well-known litigator up in Burlington who was not known for speaking very quickly, and was doing an oral argument, and I don't know if this was apocryphal or not, but supposedly the red light went off, and he said, "But Your Honor, I just got past my introduction." And it being sort of the older days, they allowed him to continue and make his argument.
He's got it. You're working out.
Okay. Excellent. Okay, here we are. Start my clock now. Give me that extra time. Okay, fall of House 11, recent changes to the Establishment Clause. I should say this is sort of an anti-PowerPoint presentation rather than one that is intended to actually visualize. So let's start with what we're talking about, which is the first clause of the First Amendment that says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Establishment Clause, when it was initially drafted into the Constitution, applied only to the federal government, and we know that because 9 out of the 13 colonies actually had established religions in their state. You had the official state religion of Georgia, Maryland, and Massachusetts, for example. The clause has generally been interpreted in one of two ways. One, to prevent the federal or state government from creating or endorsing a religion, and two, from preventing federal or state agencies from interfering with the free exercise of religion. And that cites to the Reynolds case, which is an early case dealing with religion when it first sort of came up as an issue, which was in the federal courts, which was dealing with Mormonism and polygamy. But note that Reynolds which upheld a law against polygamy, stands for a principle that the Constitution will allow laws that prohibit elements of the practice of religion where they conflict with the laws of the United States. So it's not simply a separation. The state can still regulate religion to the extent that religion does not trump the laws of the state. The Establishment Clause did not erase religion from the public spheres, and prior to the 14th Amendment, it did not prevent states from endorsing religion, the 9 establishment churches. But continuing further on, in Vermont, for example, Christian ministers delivered what was known as the election sermon before the legislature, before the governor, before the lieutenant governor, council, court, every election day. And these were not secular, hey, why don't we feel good about voting today type sermons. This was the wrath of God and the Lord Jesus Christ may be brought down upon you, and here are the good things we need to bring under the good word of the good book. If you want to learn more about those, Paul Gillis has a wonderful lecture on that in the Ethan Allen Institute, and is collecting these election sermons, but they're actually available on most of the internet. More modern examples include any of your coinage. It says, "In God we trust," the Pledge of Allegiance, "One nation under God." And as we've seen in more recent cases, Town of Greece versus Galloway, actually invocations at the beginning of public meetings do persist as a practice. Book note that, it will come back later if I beat the clock. Okay. As early as 1878, however, we have an interjection of this metaphor from a letter that Thomas Jefferson wrote to a buddy that says there's a wall of separation between church and state. And Reynolds, the case we talked about before, suggests that, very mild kind of way, but introduces this idea that Justice Hugo Black will pick up on about 70 years later when we get to Everson. Everson versus Board of Education deals with laws in which the states of Pennsylvania and Rhode Island are giving money to religious schools, 15 cents, I think, per student per day in Rhode Island, some percentage in Pennsylvania, to support but only for secular purposes. And Hugo Black, Justice Black, writes a decision that says, that's okay, but look, we have a separation between church and state, and we need to keep that firm. And he creates a test that has 2 prongs, essentially. Is the primary purpose of the assistance secular? And is the assistance to neither promote nor inhibit religion? So it's a 2-part test from Everson in 1947. Justice Jackson calls baloney on it all and says, look, if we give money to a religious school, we're essentially funding religion, and I don't like that. And so he says it a little bit more eloquently because, of course, this is talking about Justice Jackson, one of the best writers on the court. But he points that out, that this is not something that we can necessarily sort of have both ways. Whereas Justice Black says, no, we can accommodate this. This will work, but really we want a wall, we want to separate this, and creates this idea that there has to be separation. And what's important about that conceptually to think about is really before that decision, we don't have that firm separation. Christian symbology and tradition blend in, and are parts of government. So we see with the election sermon, we see with some of the early monuments that state actors would often erect that would incorporate Christian symbology into it, or other types of religious symbology that would be incorporated into it. The Establishment Clause, in its first part of the United States history, doesn't have this wall of separation. But with Everson, up goes the wall, and philosophically, it's a very attractive idea because we're becoming a pluralistic society. We're well into becoming a pluralistic society by 1947, and so creating that separation creates a certain safety for those groups that are coming in and don't feel like they're necessarily part of that or older Christian language, and feel inhibited or feel that they're being excluded by the use of it. Okay, so now we come to Lemon versus Kurtzman, and this is Justice Berger writing the decision in 1971, who's like, I like Everson, but I think I can do it a little bit better. And like a lot of things Berger did, maybe not. Just kidding. But Chief Justice Berger writes, and in this time, actually, I'm sorry, this is where Rhode Island and Pennsylvania have the funding. The earlier one was yet another school funding, but I'm getting ahead of myself, I apologize. Under Lemon, he creates a third prong. So you take the first two prongs of Everson and you add the third, which says assistance does not lead or create to excessive entanglement between church and state. So this is where we get the prong of excessive entanglement. So in the test in Lemon, actually in the facts of Lemon v. Kurtzman, we have the first two prongs of that actually the Rhode Island and Pennsylvania schools, they were fine with. They met that and they would have passed constitutional muster, but Berger and the court says, no, we're going to add this third prong, and you don't meet this prong because you're creating an excessive entanglement. In some ways, bringing back Justice Jackson's ideas into this and saying, wait a minute, if we're getting into a sort of ongoing funding relationship with a religious institution, we're really kind of funding a religious institution, and this kind of excessive entanglement is exactly what we don't want when we want a wall of separation between church and state. Now, the third prong has other sort of characteristics and standards that the court looks to. The court looks to the character and purpose of the institution that benefited, the nature of the aid the state was providing, and the resulting relationship between the government and the religious institution. If the program fails any one of those, it's unconstitutional. And another point from Everson is that he doesn't use strict scrutiny, but he uses the term the highest or strictest scrutiny of any type of Establishment Clause case. Okay. Whoa. And with that, they're off. Okay, so when you have Lemon, you make lemonade at the district court level. This is really, maybe some higher powers speaking up here about this Establishment Clause. Okay, Lemon upon enactment, upon its issuance, becomes extremely influential. From Lemon, we get Justice O'Connor developing an endorsement test, which defines an excessive entanglement as one that would appear neutral to a neutral observer as endorsing or disapproving of a particular religious practice. That's Lynch versus Donnelly in 1984. Now, Lemon immediately starts to also get its fair share of criticism. It promotes, in certain cases, an artificial distinction and between religious and secular activities where one might not normally be warranted. And there are a number of examples: historic preservation, education, as education becomes more and more unbound to the single one-room public school model and expands into choices and such, this starts to get into some messy entanglements. Again, looking at Vermont, many towns use religious assembly space to supplement and augment municipal facilities. Burlington, for example, our largest city, has one of its polling places in a church. And every election day, somebody from the elections team goes and puts paper over the religious iconography. Thank you very much. I guess we're not getting that far. Let me move a little bit further. Okay, so the point about Lemon is it gets quickly into excesses, where people are trying to rewrite history and scratch out the religious institutions. Nobody hated Lemon like Scalia. If you ever read anything by Scalia, this is wonderful. He compares it to a ghoul that rises up to scare us when we want to, and we keep dead when we don't want to, and he wants to stab it in the heart with a pencil. So we have Kennedy. Kennedy wipes out Lemon, destroys it, completely eradicates it, and it is really trying to reverse it. Now we're looking at historic contexts to Establishment Clause cases, and with Gorsuch, he goes back to Town of Greece versus Galloway, and he says, we don't look to excessive entanglements. That's an artificial distinction. We look to historic practices and understanding. And so in Kennedy, the Establishment Clause and the Free Exercise Clause must be read as complementary clauses. He believes that Lemon improperly turned them into warring provisions. We have to read them together. We're always going to have religion in the public common. We are always going to have religious iconography because of our history, and we just have to, in his words, tolerate it. And so he ends up but the question becomes, what are historical practices? Because that's about as loose of a term as excessive entanglements. There are, in the town of, and what I would say is that, Kennedy involves a high school football coach who kneels at the 50-yard line and starts praying, and everybody comes and prays around him at the end of a high school football game. If you grew up in the Midwest and watched many of these high school football games, you'd be saying, so what? Because that is something in that culture that is linked and joined very closely. And so in some respects, it's going to be a really difficult question. Now, here in Vermont, I can tell you, having watched many of my children's sporting events, I don't think anyone prays, except to maybe end the game a little bit early. Maybe that's just me. But it's not a religious, that connection. And so I think we may end up with, under the Kennedy test, a lot of inconsistencies depending on where you live. If you are in a religiously affiliated area, maybe prayer has that long historic tendency to be there. But, and we have that with the town of Greece, where the court said, hey, this is a long-standing tradition. These kind of election sermons have been going on since the founding of our country. We can tolerate a little prayer at the start of our meeting, as long as it's trying to rotate it up a little bit. I'll leave the last word to Professor Eugene Volk, who long before the Kennedy decision was advocating for what this kind of historic version of the Establishment Clause would look like. And Professor Volk really talks about the idea that we're scaling back the Establishment Clause. We're not looking to police any type of entanglement or religious mention. We're really pulling back to the question of, is the state endorsing a religion? And he has a 6-part test that he advocates for that. And he simply says that that's not going to, that's what the court's going to do. And I think actually he has the right direction as to where this court is going to go in the future, which is we're going to see a lot less of these cases. And having been a former municipal attorney, I would tell you, you would get an occasional letter from the American Atheist Society who would say, you can't give a historic preservation credit to that church, or you can't have their polling place at a religious institution because of the Establishment Clause and excessive entanglement. I think you're not going to see those cases anymore, and it's going to be very much almost similar to the Election Clause cases, where it's really going to be just this bare threshold. If there's a particular type of entanglement, of a establishment type situation, the court's going to be all over it. But if not, they're not going to have cases that tolerate that. Thank you very much.
I'll tell you, what an incredible presentation, what an ambitious program this was, to have 5 presenters on constitutional law in an hour is pretty remarkable. We've gone a few minutes over, but we're happy to, and when I say we, I'm saying I'm on behalf of the panel. The panel is happy to answer any questions you might have, any issues, suggestions. That's it. I think they're ready to get out of here. Well, thank you so much for your attention. We really appreciate it, and thank you to the great panel.